If you want to be connected with my channel, press the subscription button and also press the bell icon. Friends, today we are in the world of ABCD. A for artificial intelligence, B for blockchain, C for cloud, and D for data. So today's discussion is cloud or cloud computing. What is cloud computing? As per Mark Andreessen, the cloud is a smart, complex, powerful computing system in the sky that people can just plug into. In 1993, the term cloud computing was used to describe the distributed computing. This smartphone has become so popular. The reason, obviously, the invent of cloud computing. Smartphone does not have that capacity to store the data which you are enjoying every day. And thanks to the concept or the infrastructure of cloud computing, which is actually providing us the infrastructure when we are logged into the cloud. See that there's a huge popularity of various smart devices. We heard of Internet of Things or Internet of Everything. I'm going to make a separate video on this Internet of Things or Internet of Everything, so its security and privacy issues. Take this example of a smartphone. When we are using a smartphone does not have that capacity to store the data and supply you data whenever you require. We are logged into the cloud in the distributed computing system, and we are using the data, sharing the data, and we are fulfilling our purpose when it is required. So that is the in today's technology. That's why the cloud has become so popular that cloud has become a household term. Say when you are purchasing a smartphone, your manufacturing company, when providing you software, is providing you with a shared online space. And even you go to the Google, you are going to have a Google Cloud, and these are the things actually are nothing but the structure of distributed computing on the networking platform. Cloud is more based on networking infrastructure. So I'm going to discuss about in this video what is cloud, and then what are the laws behind the cloud, especially for India, the liabilities and the laws of the cloud in India, and what are the challenges behind a cloud services, what are the future of cloud services, and the most important thing, what our government is thinking in popularizing concept of cloud will also be discussed about in this video. Additional point I'm going to discuss about here is the cloud forensic. And what is the cloud forensics or network forensics? Cloud forensics is a part of network forensics, and how the cloud forensics and how it is being done, and what are the flaws into the cloud forensics. So please watch this video till the end. Just friends, imagine that you visited Delhi and you stayed there for 1 or 2 days, and you have some assignments or engagement there. Completion of your job, you return back from Delhi to your destinations. So whenever you are in Delhi, you are not going to purchase utensils, the vegetables, the other eatables, and you're going to hire the gas cylinder and the oven and all these, and then you're going to cook and then eat and then go for your pre-scheduled job. What you're going to do, you're going to just pay and use. That means you're going to pay and purchase some foods in a hotel or any other place, and you'll eat. So the thing is that in today's world, if a company has an annual turnover of 1 crore rupees, so that company is not supposed to purchase a software or infrastructure which is more than their turnover amount. So what they are going to do, they are going to pay and use it. This concept is actually behind the popularity of the concept of cloud computing, as the people say, because in today's world we need something on rent, we need something on deployment, we need something an infrastructure from a third party. In computing world today, we are in the world of distributed computing. You will see that there is a huge popularity of smart devices. So the first thing is, what is cloud computing? The cloud computing as defined by the Wikipedia: on-demand availability of computer system resources, especially data storage and computing power, without direct active management by the user. Very simply, in cloud computing, the computer resources, generally more popularly the data storage and other computing power, these are available on whenever we made a demand, or that is available on demand, without any direct active management by the user. when you are using, do not require any active management as a user using this data. We don't need to have a direct active management of the entire infrastructure, but on demand the computer resources, especially the data storage and computer power, is available. So that's the beauty of cloud computing, and that is the reason that cloud computing has become so popular. Now the most important thing in cloud computing parlance is that cloud is developed only for the purpose increased accessibility to the computer resources. So now with the advent of cloud computing infrastructure, now the data and the data and other computing power has become more accessible to every part of the world. So that is the reason the cloud has become so popular. Next comes the cloud computing types. So cloud computing types are depending on the deployment model, and three popular models. One is public model, another is private model, and another is a hybrid model. In public model, the infrastructure here is open for public use. And in case of private model, the cloud infrastructure is used for single organizations. And in case of hybrid cloud, it is nothing but a hybrid or a composition of both public cloud and the private cloud, both public cloud infrastructure and private cloud infrastructure. So and another concept is the standard models of cloud computing services. So if I say the nature of services provided by a cloud computing infrastructure, we can divide these standard model relying on the cloud computing services on three parts. One is platform as a service, that is PaaS, the infrastructure as a service, and the software as a service. And all these three types of things, we're going to see that a consumer who is using the cloud infrastructure, in case of infrastructure as a service, to deploy and run arbitrary softwares, and in case of platform as a service, the consumer are able to deploy on the cloud infrastructure, and in case of software as services, the consumer can use the provider's applications on running on a cloud infrastructure. In a broad perspective, where we can have a segregations of three types of model depending on the cloud computing services. So now one important forensic field is coming up from the development of the cloud is called the cloud forensic. Cloud forensic is basically part of network forensics, but because today more and more in criminal investigations, when the investigating agencies and other law enforcement agencies are finding out the evidence, in most of the cases their evidence might be in a cloud, another cloud server, another. So when these evidences are being collected and presented in a court in a forensic way, so the acceptability of that evidence definitely the subject matter of the cloud forensic, and obviously which is part of a network forensics. And in cloud forensic, the network traffic is being analyzed, the log being analyzed, the web access data being analyzed, email data was also analyzed. So this is one of the part of cloud forensic. The most important thing about the cloud forensic is that the collection of the data or information from the cloud in a forensic friendly way. So this is a huge challenge. There are experts in whose opinion that cloud computing environment is not always forensic friendly. So there are instances where the evidence coming from the cloud or evidence existing in the cloud service in providing cloud infrastructure may not always be the forensic friendly. So that's one of the negative thing of a cloud infrastructure. Then come the cloud platform. The very simple question is that what is the status of a cloud service providing company or a cloud in Indian parlance? The cloud is nothing but, in a single word, the cloud service providing companies or the cloud infrastructure providing companies are nothing but intermediary as per Indian law. So intermediary is defined in Information Technology Act 2000 section 2 subsection W. So section 2 subsection W says what is intermediary. With respect to any particular electronic records means any person who on behalf of another persons receive, stores or transmit that record or provides any service with respect to that record, and includes telecom service providers, network service providers, internet service provider, web hosting service provider, search engines, online payment sites, online auction sites, online marketplaces and cyber cafes. So these are the areas which is included within the definitions of intermediary as per section 2 subsection W of Information Technology Act. And if we see the nature of the service provided by the cloud, the service provided by the cloud is very much within the ambit of intermediary. So cloud is nothing, cloud computing service providing companies are nothing but intermediary as per Indian law, and so they are liable to comply or discharge those responsibilities which is laid down which is there for any kind of intermediary. So let us see what are the liabilities are there for intermediaries, what are the liabilities of a cloud service providing companies. So the one section is section 43A. It is regarding to the compensation for failure to protect the data. So when there is data, because in most of the cases cloud is popular for dealing with the data, and when these cloud service providing companies are not been able to protect your data, they are also be liable as per laid down in section 43A of Information Technology Act. So as per section 43 of Information Technology Act, where a body corporate possessing, dealing or handling any sensitive personal data or information in a computer resource which it owns, control or operates is negligent in implementing and maintaining reasonable security practices and procedures, and thereby causes wrongful loss or wrongful gain to any persons, such body corporate shall be liable to pay damages by way of a compensation to the persons so affected. The Personal Data Protection Bill has come in India, and we already have the international law that is called GDPR. The data being handled by the cloud service providing companies are subjected to all kind of liabilities laid down in Indian law as well as the international law. Another section is 72 of Information Technology Act. It relates to penalty for breach of confidentiality and privacy. Save as otherwise provided in this act or any other law for the time being in force, any person who, in pursuance of any of the powers conferred under this act, rules or regulations made thereunder, has secure access to any electronic record, book, register, correspondence, information, document or other material without the consent of that person concerned, discloses such electronic record, book, registers, correspondence, informations, documents or other material or to any other persons shall be punished with imprisonment for a term which may extend to 2 years, or with fine which may extend to 1 lakh rupees, or with both. So that is the provisions in case of penalty for breach of confidentiality and privacy. Next comes the section 72A of Information Technology Act. It says it relates about the punishment for disclosure of information in breach of lawful contract. As per section 72A, save as otherwise provided in this act or any other law for the time being in force, any persons, including an intermediary, who, while providing services under the terms of lawful contract, has secured access to any material containing personal information about another persons with the intent to cause or knowing that he is likely to cause wrongful loss or wrongful gain, discloses without the consent of the person concerned or in breach of a lawful contract such material to any other person shall be punished with imprisonment for a term which may extend to 3 years, or which fine which may extend to 5 lakh rupees, or with both. This is a cognizable offence. That means FIR can be by the investigating officer when there is a complaint to that effect. Now another very important section is section 79 of Information Technology Act. It provides the liability of, or how much the liability of the intermediary, or how much the intermediaries are liable. It is defined in our section 79 of Information Technology Act, and it is equally applicable in case of a cloud servicing providing company. As per section 79, it relates to intermediaries not to be liable in certain cases. So it says about where the intermediaries are liable and where the intermediary is not liable. So as per subsection 1 of section 79, it says, notwithstanding anything contained in any law for the time being in force, but subject to the provisions of subsection 2 and 3, an intermediary shall not be liable for any third-party information, data or communications link made available or hosted by him. Subsection 1 is providing a relaxation to the liability, but it is subjected to subsection 2 and 3. So let us see what is there in section 2 and subsection 3. So in section 2 of section 79 of Information Technology Act, In subsection 2 it says the provisions of subsection 1 shall apply if the functions of the intermediary is limited to providing access to a communication system over which information made available by third parties is transmitted or temporarily stored or hosted, or the intermediary does not initiate the transmissions, select the receiver of the transmissions, and select or modify the informations contained in transmissions. The intermediary observes due diligence while discharging his duties under this act, and also observes such other guidelines as the central government may prescribe in this behalf. So you see, the most important true thing is that the provision of subsection 1 shall apply in case of the function of the intermediary is limited to providing access to a communications. The limited portions is the liability portions. The intermediary does not initiate the transmission, select the receiver, and the purpose of the intermediary, and the most important thing, that whether the intermediary has exercised the due diligence or not, and whether the intermediary follows the guideline provided by time to time by the central government as prescribed on this behalf. So that is the point. They have to follow the due diligence and the law of the land. Now, in subsection 3 of section 79, it says that the provisions of subsection 1 shall not apply if the intermediary has conspired or abetted or aided or induced, whether by threats or promise or otherwise, in commissions of the unlawful act, upon receiving actual knowledge or on being notified by the appropriate government or its agency that any information, data or communication link residing in or connected to a computer resource controlled by the intermediary is being used to commit the unlawful act. The intermediary fails to expeditiously remove or disable access to that material on that resource without vitiating the evidence in any manner. There is an explanation for that purpose of this section. The explanation: third party information means any information dealt with by an intermediary in his capacity as an intermediary. So these are the very important provisions. Subsection 1, subsection 2 and subsection 3 is giving a clear-cut concept, is wherever is the situations where the intermediary is liable or not, and obviously in the same footing whether the cloud servicing providing companies are liable or not. So if in case of a cloud servicing providing company doing business in India, and they are to be careful about section 79 and other provisions which I have discussed just now. So there are other rules also in case of intermediaries liability or the cloud service providing companies liability, and two rules are very important, and these rules are framed under the Information Technology Act. And the first rule is the Information Technology Intermediary Guideline Rules. This is directly coming under section 79 of IT Act, and as per these rules, especially the rule 3 is very important, where it is laid down the due diligence to be observed by the intermediary, the entire things, and this due diligence has been laid down in that rule 3 of these entire rules of 2011. And another important rule is that the information technology reasonable security practice and procedures and sensitive personal data or information rules 2011. In this case, the information technology reasonable security practices and procedures and sensitive personal data information rules is also called the IT rules 2011, and this rule provides us how these entity starting from cloud servicing providing company or the company who are dealing with the data, how they are going to exercise their due diligence in dealing with the sensitive personal data or informations of a persons. That is the law of our land. If we go by the government policies, you'll see that there is a huge encouragement of this very important infrastructure developing in the world. So in our national telecom policy, you'll see that the cloud has been mentioned as a very important infrastructural issue, and infrastructure of cloud has been encouraged in that national telecom policy. And another very important thing, our government has developed its own cloud that is called GI cloud or Meghraj. It's also called the Meghraj. It's a Government of India initiative. This was developed to utilize the benefit of cloud computing. So friends, you can visit the websites cloud.gov.in. It's a fantastic initiative by the government to make the infrastructure or to bring the benefit of cloud computing to the people at large. So there are huge challenges which the cloud computing platform is facing, and one of them is crimes where cloud can be the subject, object or tool related to the crimes. And that is one of the reasons that provides a challenge to the law enforcement agencies to collect the data, extract the data from the cloud. Because, for example, in different BPO scam and other thing, there are crimes. We have seen that the companies who are defrauding the people are not actually using any standalone server installed in their office. They are actually using the server from through cloud. So they are logged into their cloud server, and from the cloud server, if the investigating officer has to make a successful case, he or she has to collect the data from the cloud server. That is one of the challenge. And like the other platforms in the online internet world, because of the cloud is becoming very popular networking infrastructure, or as a whole model, or a model as well. So in this kind of deployment model, or as a whole model, the cloud is actually being used or subjected, being the subject, object or tool related to many of the crimes. And the next point, the next challenge the cloud computing is facing is that increased accessibility. The cloud was popular. The main reasons, one of the main reasons of the cloud being more popular is the increased accessibility. But here what happens is that increased accessibility is falling into the hands of few monopolistic companies, and they are trying to make a monopoly out of it. So they are controlling the entire thing. So this is one of the huge problem, where the increased accessibility through few monopolistic business entities is actually making the accessibility rather more restrictive, and at the whims or at the hands of those monopolistic business entities. So third point is the privacy breach. Is a very important point, because in cloud, the most important challenges or the problem the people are facing with respect to cloud service is that of privacy. The second is the security, and the third is the jurisdictions, and copyright or intellectual property issues are there. So privacy breach or data privacy is always there in case of a cloud, because there is always a possibility that the data being disclosed accidentally, or it may be deliberately. It is also seen that and another huge problem is the applicable law or the jurisdiction. Say for example, you are accessing cloud service from a server which is stationed at any part of the world, not within your country. Then if there is something happens, some legal litigations happen, the law of the which country will going to prevail, and that's a huge problem of jurisdictions or applicable law. And another important thing is the data protections or the data security, because in case of a cloud, accessibility is so easy, security can be more compromised. Last but not the least is the copyright issues, IPR related issues. Say for example, trademark infringement or other copyrighted issues are there, which is inherent with the cloud service providing companies. So these are the challenges, and there are other challenges as well. So thank you friends for paying the attention and watching this video till the end, and please subscribe to my channel so that you may not miss any of my videos. Please wait for the next video to come.